May it please your Lordship?
Yes.
Lordship, I beg to mention item number 11, your Lordship. Your Lordship, the conducting counsel is indisposed. Kindly grant 2 weeks' time. We have already informed the opposite counsel as well.
No problem. 11. At the request of the petitioner, list after 2 weeks. Yes. Deputy.
May I please your Lordship? I beg to mention item number 4, your Lordship.
Number 12.
4, your Lordship. I pray this matter may come up after 2 weeks, your Lordship.
Why?
Personal difficulty of the conducting counsel, your Lordship. Personal difficulty of the conducting counsel, your Lordship. No objection, your Lordship.
Or also same order. 2 weeks at the request. Yes.
Much obliged, Lordship. Obliged, Lordship. May it please your Lordship. Your Lordship, I beg to mention item number 6, your Lordship. Your Lordship, the conducting counsel is indisposed. We pray that this matter may come up after 2 weeks, your Lordship.
Dr. Mojika?
Yes.
Dr. Mojika?
Yes, your Lordship.
Who appears for the petitioner?
Your Lordship, Mr. M. Prasad. I think he comes through VC, your Lordship. He has not come through VC today.
So then,
Your Lordship.
you will inform?
Yes, your Lordship will inform.
Yes, at the request made on behalf of Dr. N. Magical Honest DSG. This matter after 2 weeks. Yes.
Your Lordship, similar prayer for item number 7.
Yes.
I am the petitioner for 7. There's some urgency in the case, but then of course, I believe he's just underwent an operation. But if you can have this matter on Thursday, if it's possible.
Up to him, you see, we do not know what about his health condition.
The problem here is, my lord,
the court will take up the matter whenever you are ready.
Well, the problem, my lord, here is, my lord, the applicant, my lord, the petitioner has also filed an application for suspension of sentence. My lord, he has almost served half his punishment, and my lord, the father of this person has taken seriously ill.
When did you file an application for suspension of sentence?
Well, along with the writ petition, my lord.
This is a 2022 matter pending. Till now you have not got that application.
Because for some reason or the other,
whatever
the
it is,
could
you
not
see,
be.
there is no question of deciding the matter in piecemeal now.
Well, I'll satisfy this court, my lord. There are certain judgments of the Supreme Court also, my lord.
Whenever, see,
If possible on Thursday, my lord.
it is not. This is not possibility. Is not dependent on the court's thing.
But I'm just asking my learned friend. I've spoken to my learned friend as well.
You just see.
Your Lordship will seek instructions with regards to
That's the
that.
problem. We'll have it after a week then. Such a
My lord, if the matter cannot be taken up, then at least my miscellaneous application may be
same order
disposed.
on the request of so and so. Just say after 1 week only. Okay. Yes.
Obliged, lord.
May I please, Lordship? Your Lordship, I beg to mention item number 5, Your Lordship. I'm appearing for respondent 3, 2, and 4, Your Lordship. I humbly pray let this matter be taken after 2 weeks, Your Lordship.
Why?
Due to some personal difficulties, Lordship.
What is this matter about?
This is a service matter, Lordship.
You have no objection.
No, Lordship.
Termination.
Yes,
Yes, Your
Lordship.
Lordship.
2018 thing is pending like this.
Yes, Lordship.
This is also at the request made on behalf of the respondent number. You are there, Mr. Abraham.
Yes, for the state, yes, Your Lordship.
That's the request made on behalf of respondent number so and so. You just say a prayer has been made on behalf of so and so to adjourn the matter. The learned counsel for the petitioner has no objection. Then you shall list this matter after 2 weeks.
2 weeks, Your Lordship. Much by Your Lordship.
Obliged, Lordship.
Your Lordship, I beg to make mention of part 2 of the hearing list, item number 8, Your Lordship. The senior counsel A. Siddiqui is through VC on this. This matter may be taken after 2 weeks, Your Lordship.
Anyone here? Yes.
Yes, I am appealing for the petitioner.
Yes. You have any objection, Mr.
No, madam, sir.
This is also at the request made on behalf of the state respondents. List this matter after 2 weeks. Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 12. The conducting counsel is in some difficulties, Your Honor. Kindly allow 1 week time.
Counsel for the petitioner.
Yes, Your Lordship.
No objection, Your Lordship.
This also 12, 2 weeks at the request of the petitioner. Yes.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to make a mention of item number 10, Your Lordship.
Yes.
Lordship, I pray if this matter may be taken up after 2 weeks, Your Lordship. As the conducting counsel.
No objection.
Is ready with no objection. Yes. Same order 10. Petitioner at the request of the petitioner. List to do. Yes.
Much obliged.
Obliged, Lordship.
Please, Your Lordship, I beg to mention item number 9. Grant us 2 weeks' time.
You are
Appearing on behalf of respondent number 2 and 3. Inform the petitioner, Mr. J. Shila. So appearing through VC.
And we are appearing on behalf of the state, Your Lordship.
What is this matter about? This one?
The
If asked
Wait,
washing of
Your
a
Lordship.
case.
for
Poxo
quashing the
motion.
case.
You are for the
Respondent 2 and 3.
they are the survivor or the complainant?
Survivor.
You are opposing the plea of the petitioner.
No, they are
No,
not.
no.
That is a this thing romantic outcome of
Yes.
romantic relationship. Now issue is pending.
No,
with
no, not
petitioner.
that. It's about injury in the body of the person. It's not a romantic relationship.
What?
No, is
Oh,
it-
romantic? No, it's not.
This is not a
romantic.
Poxo matter.
It's
Is it not a
not.
Poxo?
No, it's not Poxo, Your Lordship. It's
It's
just
307
injury,
attempt
plain,
to murder.
Yes. Okay.
simple injury.
There is a settlement between the parties.
Yes.
Yes, Mula.
Okay. Okay. When do you want it?
2 weeks' time.
This also after 2 weeks of the request made on behalf of such and such. Yes.
Obliged.
Obliged.
Your Lordship, I would like to mention item 14.
14. Yes.
14,
You are
Lordship.
appearing for
For preliminary for the petitioner.
petitioner. Yes.
I pray that this matter can be taken up after 2 weeks.
Yes.
No objection, my lord. Senior counsel.
14
K.
2
Khan
weeks
is
of the request of the petitioner. Yes.
Obliged, Your Lordship.
Daily causeless. Item number 1.
Please, Your Lordship.
Yes.
Lordship, this is an application under section 389(1) for suspension of sentence. The state was directed on the last day to seek instructions. The reason
Suspension
behind
of
seeking
sentence.
suspension of
Yes,
sentence
Your
For
is
seeking
that-
instruction, suspension of sentence, or
From the doctor, Your Lordship.
or it is for
because seeking instructions because the accused person is supposed to be paralyzed as well as his arm has been amputated, and we have received instructions from the medical health officer
yes.
who says that he was under medical care by the medical and health officer, district prison and correctional home, Joy. However, I strongly recommend for his release from the prison if considered, so that the convict can be taken care of by his family members outside the
So
prison.
you have no objection that way.
Doctor, both his arms are not working. One is amputated, one is paralyzed.
What is the conviction here?
7 years, Your Lordship.
This matter is otherwise not ready for hearing.
Not yet. We are waiting for the paperwork, Your Lordship. We are waiting for the
Paperwork is being
paper.
prepared. The matter was directed to be listed after 4 weeks.
We'll just
Can you
submit
pass
this.
your
Can you please?
Now, LC record has come here or what? Lower court record is here.
LCR has come.
Clear
Lordship.
yet whether it's coming.
Now then, what will happen if in case the court grants him bail?
Lordship, at present, the matter is pending for preparation of paperwork. In the
That is all
meanwhile,
right.
Your Lordship,
If any order of bail is passed, the bail bond has to be accepted by the trial court.
Trial court.
So if record is here, which way trial court will accept it? So there will be a problem again.
It is also there, Your Lordship.
What is the procedure to be followed here in such a case?
Lordship, generally when a suspension of sentence is moved, it is moved at the initial stage and the trial court record is still there itself.
We are not in the initial stage now. Record is before us.
Yes, Lordship, that is the point, because
That is-
I have been engaged as legal aid counsel recently. It was
That is,
initially-
but forget about which way we tackle with the situation now. That is the main thing.
Lordship, I pray that since the paperwork is already under preparation, the LCR may be sent back after keeping the relevant record.
The problem is that if it is
relevant records.
no, it cannot be. See, what will be relevant and what is not relevant. This will create problem.
Lordship, 2 weeks ago the order was passed to prepare paperwork, so we can find out the status from the judicial.
That is what we will do.
We'll do that, Your
We'll
Lordship.
take up this matter day after tomorrow.
After finding out the position of the paper book.
Just as requested by the parties, list paper tomorrow. This one, you pass it on that day? This
Yes,
is the
Your
original.
Lordship. Yes. Let them find out.
Please find out what are the solution by that time.
Yes, Lordship.
In this kind of situation, how do we tackle it?
Lordship.
Pleasure, Lordship. What? Order is it?
Yes.
Hearing item number 2.
Please, Lordship.
Yes.
Lordship, I am praying this matter may come at the end of the board, Lordship.
The end of the vote.
Yes, Lordship.
End of.
Reply.
Item number 3.
My lord, in this item also I am praying if the matter can come at the end of the list, my lord, because senior counsel due to personal difficulty is unable to reach now.
Mr. Shangreshi, you were supposed to find out some question of law.
My lord, regarding this.
Regarding the power of the collector.
Yes.
Yes.
And second point is the instruction from the.
We have received the instruction that
their full amount or not.
We have paid,
That
my
is
lord.
all right.
That
Then-
we got the instructions.
Okay. Then what about that thing, that proposition of law which you are saying? Otherwise, that was the main issue. Say like if we remand it, whether collector can decide it.
My lord, that one under section 76 now under the new act.
Your submission was on the last occasion was that you are under impression that the collector has some power. This situation to deal with the issue. The view of the court is that the only solution was under section 30. So that is what you are supposed to find out. That is what.
My lord, regarding the limitation, the time limitation period for moving the collector.
Not limitation period. Well, perhaps this was your submission. At least what this could gather from you is that the power of the collector.
Yes.
So that is what is to be seen. Say supposing if it is remanded back at this stage.
Yes.
The authority of the collector to amend the award or pass some order with regard to your claim, right, for inclusion of your name in the beneficiaries. Where is the authority after everything is completed? We are not we have crossed that stage of section 9.
Yeah.
And as per the submission made by Mr. Shangupta just now, that payment also has been made. All the payment has been made. So,
right. Now, since my lord, if award is passed in my favor also, and if I ask for alteration or modification, then under section 11, there's a finality of the award. But in my peculiar favor of the case is that here award is not passed in my favor. So according to me, my last submission was collector has still the power because he never passed any award in my case.
So that is
so
what then only solution is section 30 then nothing remains. Then you have to pass this order on section 30.
My lord, section 30 is one option. Exactly.
That is only the thing. Yes. But then your submission was something else on the other day. You said even the collector also will have some power at this stage. And that is what he wanted to find out.
Now what about the section collector after he passed an award? Then it becomes finality between him and the
that is precisely what the section 12 says or section 11 says.
Right. And when the reference court passes an order, then the collector has even the power to pass a fresh award order also. And lordship, if lordship direct him, then
the order of the reference court is a judicial order.
Judicial order.
But then this court is not in a position to do that.
In my case, lordship, I understand. If lordship satisfied, then see, collector, you did not pass any order regarding his notice after issuing notice. You did not even pass any order regarding his representation or for fixing a fresh date. Even you did not pass a disposal. You did not even pass an order that notice was wrong. Coupled with the non-certainty of the award order, date of the award. If lordship direct, according to me, the collector has still the power to consider and pass order.
Show
Otherwise,
some,
Section 30.
Show us some law. If there is submission, otherwise this court is not at all convinced. If you do show some authority of law, otherwise once the award that is finality, it remains there until and unless there is order passed by special judicial officer in this regard. Otherwise not. There is no question.
But I do admit.
The fact remains that you have not filed any application for seeking reference under Section 30.
So, yes, those formal application was not there.
That is what. Only thing is that your thing is that the violation of your right under Section 9.
Yes, yes.
This your submission that the you see, like directing collector to pass some order at this stage, it seems to be not supported by sound proposition of law until unless you can show something.
In fact, that was also not one of my prayer, in fact. But in any case, my lord,
No,
that was one of the...
the question is that what kind of relief we can extend you at this stage, if at all this court finds it right.
That Section 9 is one thing, and Lordship has clearly pointed out Section 30. That one is already there, without limitation also. 2007, judge provided for moving, or for the collector to pass.
That is definitely.
Yes, that one
Now
is.
then in such a case, then only we can pass that order, probably giving a liberty to approach the collector, file an application under Section 30, and collector may refer it
In accordance with law. I think that will be
We will
the
take up and decide the application.
decided on merit whether they
We cannot make an order also for reference.
Therefore, the award, with your permission, the award can be passed under two circumstances. One is my land is taken away, collector issue notice to me, under Section 9, I don't appear. And he passed the award in my absence. In that case, I can go for Section 19 or 18 or 30. Another one in my lord, my land was taken away.
No, Section 18 and 30 is not coming at the same time. Cannot come at
It
the
is
same
different, it is different, it is different.
These cannot come at the same time.
Yes, it is different.
It is different.
It is different.
18 is for enhancement.
18 is.
So there is the question of your inclusion is not there.
Right.
Here we are concerned with your non-inclusion.
Right, right. So one circumstance is my land taken away, collector issue notice to me, and I do not appear. He can pass an order, award order, and that award is finality. I can resort to different provision. Another one is he has taken away my land, and he never passed any award in my favor.
He has not taken away land. That is what the case
the
is.
stand is.
That is their case. They are not admitting that their land has been taken. They are not saying that Section 9 was issued in pursuant of taking over your land. They say by mistake.
By mistake.
They say it. So that is where the problem is, Mr. Shangreshwar. Your case has to go as a fresh claim. That is, it is do not no way take it as a case that the government is admitting that they have taken your land. It is
No,
not the case.
I understand. They did not admit that they have taken away my land.
That
They
is why
didn't admit.
exactly Section 30 comes.
They also did not, my lord. They also did not spell out that whose land is this, remember 45, 48, 49.
But then in your absence, you did not bring forward any land acquisition as pointed out by the state on the other day. So once there is no claim of ownership by you, what is the question of refusing? And it's all those things.
My lord,
We are only confined with the thing that the opportunity which you are entitled to under law or not, whether it was given to you.
Yes, yes.
If you find that it has been given, then so.
And last time, learned EAG say that I did not produce any document. Now, Section 19, the Section 9 notice, opportunity, that is one of the crucial moment for the landowner. There he can state his title,
See,
compensation.
this is why this clause precisely was basically asking you. What is inclusion or issuance of notice? Issuance of notice under Section 9.
Yes.
Is it a conclusive proof of ownership or conclusive proof that your land has been taken over? Here was some law. If you go this thing, matter will become simple. And they will be bound to do these things. To show us that once a Section 9 application is issued on somebody, it is conclusive that this person's land has been taken. That is what you show it. Because otherwise, see, mistake always can happen.
That is true. That is
See,
true.
your name is not there in Section 4. Plus, Section 8 also, no fresh inclusion of your name. So apparently, just because notice has been issued, we cannot just say that your land has been taken.
That is true.
So
that is
where you see this court is basically repeatedly, you see, like trying to point it out to you to show us some law, where you can compel this court.
With your respect.
Law will bind the court. So if you can show that section 9 amounts to a proof of ownership or amounts to proof that the land was taken over, then you can decide it.
My lord, we may suggest tomorrow. The issues are not available. I'll try to look into that aspect.
That is last occasion you created. The first thing about the collector's thing at this stage to do it. This is on the background that the section 9 confers some sort of right. Okay. Now what right is accrued to a person who has received notice under section?
Right. Including the
mindful of a
consequence.
thing that your name is not there in section 5. So that is where there is a difference. If your name is there in section 4, 6 and all, so definitely you have a right. But then here it is not.
Well, that's true. And may I point out, under section 6 declaration also, many, more than 30 landowners whose name are not mentioned under section 4 were included.
Can there be a case of negative equality?
I just point out.
You will establish your right.
Yes, exactly.
Just because somebody gets the benefit of wrong would not make out a case for it.
That is true. That is true. Only one aspect of the matter, the date of the award matter. I've seen the section 11A, collector, the award should be passed only before 2 years from the date of declaration.
Otherwise, proceeding will lapse. But then that is not a case where the proceeding has been lapsed. If proceeding is lapsed, there's a case. If you say the proceeding has lapsed, then you also will not have a case. Your claim also is not maintainable.
Exactly.
So you cannot contain both at the same time.
Exactly. Tomorrow, if Lordship permits.
Tomorrow will be enough, or day after?
Day after.
You have this thing, because this is an issue, it will be quite difficult to find. So probably you need some, of course it is up to you.
I'll try my best. That is.
Yes, madam.
Just said the request of the parties list day after tomorrow. Interesting issue.
Yeah, important issue, madam. Important. What is the consequence of that?
Section 9.
Section.
That is right.
Item number 13.
In this matter, we have filed application, Your Lordship, for striking off the petitioner, Your Lordship.
What is the application? What is the number? You are appearing for madam?
I'm appearing on behalf of SD, Your Lordship.
On behalf of OSD?
131 of 24, Your Lordship.
Died in 2011, 2021.
21, Your Lordship.
Is it not barred? This application is barred by limitation. What is the time stipulated for substitution?
Your Lordship. Because we have just been informed recently, Your Lordship, that
If their law says something to be done within a certain period, your information, or my information doesn't matter.
Your Lordship.
Only thing that this is a writ petition, so that provision contained therein may not apply to you. That is what is. You should be prepared to reply the things. Be aware of all those things. Do not just stand up. You have to reply to the queries of the court.
Your Lordship, actually, the counsel who are assisting in this matter is not yet.
You are there, isn't it?
Your Lordship,
You are
actually.
appearing in this matter for quite some days, isn't it?
Your Lordship, what?
And once you have decided to stand up with the petition, that becomes your duty.
Your Lordship, I apologize, Your Lordship. This is scream, Your Lordship. Yes,
The apology will not help the things. You stand up as a professional, you stand up and you perform. Yes.
Your Lordship, I have no objections with
You have
regards
no
to
objection?
striking of, yes.
Is there any limitation apply? Is this application of limitation in
No, Your
case of substitution? Oh, this is not substitution, this is striking out.
Striking out.
That is so you should say, you should tell the court. Yes. This is Miss Case number
131 of 2024, Lord.
Heard, Mr. So and so Learned Counsel appearing for the applicants. And also MS so and so Learned Counsel appearing for the respondent number 1, 2, and 3. And
I'm appearing for respondent 4 to 6, Your Lordship.
respondent number
4 to 6.
4 to 6.
Yes, Lordship.
What about 7?
7 is already by Your Lordship, expired.
Is it? Then again you have to file this application for striking out his name also. Who was representing respondent number 7?
Lordship, we have filed with regard to this order, this code 10/7/2019, Your Lordship.
What is
Strike
this?
off this striking
It
off
was
the
allowed.
Lordship.
Then why you have included him as a respondent here? In this your application? Respondent number 7, Simoti Janori Marak Machik.
Mistake.
You have to correct it. You have to correct it.
Your Lordship.
You cannot pass order
Your Lordship.
by keeping the dead person as a respondent.
Lordship.
This is.
Your Lordship, allow. Your Lordship will do the
You withdraw
correction.
this application, file a fresh one.
Your Lordship.
Just miss 131. At the request of the. You will do it within 2-3 days. You will not
Yes,
give
Your
him much.
Lordship.
At the request of the. Learned. In the request of the. Just write for by the Learned Counsel for the applicant. This application stand dismissed on withdrawal with the liberty to file afresh. Writ petition when? 1 week.
1 week, Lordship. Will be filing.
Be careful. Why unnecessary?
Lordship.
See, this court also is not inclined. You see, like this is it happened like this thing. You've been given time so many times. Even after last chance, also you've been given again. It's going limitless. Just say aspirate for by the petitioner list after a week. You do the needful.
Your Lordship.
Take care. Do not include the
Lordship.
Oblige, Your Lordship.